thank you very much for a very inspiring presentation on hybrids and becoming a front-runners, hybrids' potential role as front-runners in this debate. Next up, as the last speaker, is Tineke, Professor Tineke Lambooy, who's going to present a paper on the key characteristics that we need for sustainable companies.
Thank you very much, Mika. I will present a study that we were working on for the last year, and we is Katarina Aishiru, Rosemarie Hoordijk, another scholar from Utrecht, and myself. And what we did, it nicely follows up on the previous speaker's research, is to identify what are the key characteristics for designing a sustainable company, but then we are talking about legal models that can enable social entrepreneurs to use them. Sorry. So it has already just been said that there's a growing interest for social enterprises in literature and practice. However, the legal research is really lagging behind. And one of the reasons is that it's, again, because it's difficult to, because there are various conceptualizations and definitions of social enterprises, like what are we talking about? Are we talking about sustainability? In what form? Are we talking about social economy? But generally, we're talking about social entrepreneurs that sometimes act from a bottom-up situation, and sometimes they are a little bit bigger companies, but there's no universally accepted legal definition for social enterprises. And our study does not want to introduce or suggest that. We want to answer the question, how do innovative legal and governance structures, especially developed for social enterprises, differ from mainstream business structures? And what are the key characteristics that we could use for mainstream companies? In October 2011, the European Commission proposed a very good definition, I think, an operational definition, which was repeated in 2013 in the regulation on European social entrepreneurship funds. According to this definition, a social undertaking is operating in the social economy, whatever that may be. The main objective must be to create social impact rather than to make a profit. And the impact must be social, measurable, and positive. Typically, there's a limited or no distribution of profits because the company primarily tries to achieve social objectives. And the governance is also different because it's operated in a transparent and accountable manner, and it involves the participation of employees, consumers, and stakeholders, stakeholders that are affected by commercial activities. In our study, we started out with a preliminary study of everything that has been done so far. So there are studies from the OECD and also from Professor Cavacci at the University Institute in Florence, European University Institute in Florence. And we selected out of all those studies 6 interesting jurisdictions to study further, to examine further: the UK, Greece, Belgium, Canada, South Africa, and the Netherlands. But after going deeper into the social entrepreneurial legal models in these 6 jurisdictions, we decided to continue with 3, with the Belgium VSO, the Vennootschap met Social Oogmerk. It's the company with a social purpose. The already mentioned CIC, the community interest company in the UK. And Greece is the social cooperative enterprise. Help me, please. And in Greek? Okay, in Greece it stems from the cooperative legal structure. And the Netherlands we had to remove from the example because the proposal was rejected in Parliament, or actually withdrawn by the Cabinet. And Canada and South Africa we removed because the models that they presented were so complicated that the social entrepreneurs really cannot use them. That's what we heard from on the ground and also found in studies about, for instance, South Africa. There are too many options, too many complications, so it's not really an enabling environment for a social entrepreneur who wants to start a social enterprise. So what we looked at, were certain legal variables that are critical factors important for these legal entities, for these social enterprises. And we looked at 5 different perspectives. One is the objectives of establishment, governance, accountability and responsibility, the finance structure and incentives. And per issue, we looked, for instance, when we looked at the objectives of establishment, whether the corporate purpose had to explicitly state a social character or not, whether it's profit or non-profit. When we looked at governance variables, we looked at the ownership model and also whether stakeholders are represented in decision-making. Accountability and responsibility, we looked at external and internal transparency and also reporting requirements. And then for finance structures, we looked at legal minimum capital requirements and financial resources. And for incentives, we looked at whether there are any tax exemptions or other subsidies possible for social entrepreneurs. So how do the forms that we examine, the Belgium, the English and the Greek, differ from mainstream business organizations? For each of them we made a table, and I will only highlight a few factors per jurisdiction. So for the Belgian VSO, it's interesting that the Articles of Association must state that the members are only seeking a limited profit or no profit, and that they must describe the aim of the social purpose of the activities. The other interesting thing is that the workers have the legal right to become a member 1 year after joining the company. And then for accountability and responsibility, the directors must issue a special report which shows the social purpose, that the social purpose has been pursued. For the CIC, it's interesting to point out that that there's a CIC regulator in the UK to approve the registration of such a CIC. And the CIC must have a community interest in its Articles of Association. So it has to be tested before registration, whether there is really a community interest test. Then interesting also is the second point on governance, that stakeholder consultation and participation in decision-making happens through circulation of newsletters, open forums, constitution of stakeholder advisory groups, and other forms of mandatory consultation. So that looks a little bit like figure 1 of Professor Turnbull. Well, then we go further in accountability. The CIC must issue community interest report. Continuing with the Greek cooperative form, interesting here is also that the statutory purpose must include a social benefit dedicated to the provision of goods and services of a collective and social character. And then I point out the democratic representation, 1 man, 1 vote. That sounds very familiar for shareholders, but here it is every member that has only 1 vote in a meeting of shareholders or members, regardless of the amount of capital that it has. And then the profits have to be reinvested in the social objectives. Well, then we did one other test to these legal variables. We tested whether each of these legal variables that we identified in each of the jurisdictions comply with the Earth Charter. Well, the Earth Charter is a UN, it started out as a UN initiative, but completed as a global civil society initiative. It's a charter that really includes all the elements that supports sustainable development. It has been endorsed by 4,500 organizations, including some governments and more regional governments and also international NGOs and business organizations. It is not really a soft law document, but you could see it like an inspirational soft law document. But we use it as a basis to check whether each of these variables really support sustainable development. And this is a table that you can inspect later, because we will put that up on the website. So for each variable we tested whether it aligns with the clauses of the Earth Charter. The Earth Charter is an interesting document to read. It's only 8 pages, and it's really internationally supported by people from everywhere. There were, I think, 10,000 international civil society groups drafting this charter. Well, to conclude, what we saw as key characteristics of sustainable companies in the 3 jurisdictions that we examined in depth are, first of all, that the corporate purpose clauses are really different from mainstream corporate purpose clauses, because here the companies have to make explicit what is the value creation in the social direction, and also on environmental goals. Then also interesting is that in Greece, a supervisory board needs to be implemented in this Greek social enterprise vehicle to monitor if the activities really comply with the social object clause. Another interesting finding is the stakeholder concerns, because like in the CIC, the company must involve a lot of stakeholders. And lastly, transparency. These examples really give a concrete obligation to the directors to support on the value creation in the social dimension. And our recommendations for law reform, and that's my final sheet, is first of all, it would be good if an EU regulation would be drafted. And I think that there are many also voices now that advocate this, to adopt a company law directive that introduces a new legal form that can be implemented in national laws that enables social entrepreneurship. And secondly, if a state doesn't have the time to wait for the EU regulation, they can of course also pick the interesting legal variables from the forms that are already existing, and make own legal forms for every state that wants to set up a supportive legal environment for social entrepreneurs. Well, and thirdly, we didn't put it here. Of course, if we are looking with the macro lens, each of these examples give a very concrete idea of how to fill in all those ideas and ambitions that we discussed this morning. Okay, thank you very much.